I hope everybody is doing well and blessed. Let's get into U.S. Lopez. Let's get directly into this bad boy. Let's learn a little bit about this case. This case is very unique. And the reason why I say this case is unique is because it has something to do with something that many people are very familiar with, especially in lieu of the Columbine, Sandy Hook dealings, and so on and so forth, and deals with gun laws, economics, as well as school zones. So let's get into it. U.S. versus Lopez. All right. First and foremost, the date. It was argued November 8th, 1994. The offense actually happened 2 years earlier, 2.5 years earlier, in March 10th, 1992, at Edison High School in San Antonio, Texas. Um, this is kind of ironic because it is in Texas, an open carry state. And this is the main reason why it is extremely important that this case isn't specifically dealing directly with gun usage. It's specifically dealing with the concept of economics and understanding the laws within the nation regarding gun regarding school zones. So let's get into it again. Vocabulary to understand. There's two basic concepts of vocabulary, and I'm kind of going to spend a little bit extra time than I normally do on vocabulary on this one than any other court case that we've discussed before or will be discussing. First and foremost is a 1990 gun-free school zone, and this is prohibiting any unauthorized individuals, right, from knowingly possessing a loaded or unsecured firearm in a place that the individual knows or has reasonable understanding or belief that is within a school zone. Um, First and foremost, in the 1990s, they in the very early 1990s area, there weren't signs that we have now that specifically dealing this is a school zone. Watch your how fast you're going, and then you're ending a school zone. There wasn't signs that specified that concept. It was just a known perspective that a school may be 1 mile, like a half a mile to the right, or half a mile to the left while you're driving on the same street, or maybe on the street to the right about 2 blocks over, right? Or vice versa on the left, 2 blocks over. It doesn't matter. That those signs wasn't available or done or shown at that time. So, so that's the one concept. The second concept when it comes to this school zone is that if you notice at the very beginning, it specifically talks about prohibiting any unauthorized individual. So it leaves it in for interpretation as to who is an unauthorized individual themselves. Common knowledge believes anyone under the age of 21 or possibly even 18 if you're going into the military. So these are just kind of known or assumed perspectives within the 1990 School Zone Act. But also keep in mind that we have what's called interstate commerce clause. Now, I'm going to spend just a little extra time on this because the concept of this case doesn't specifically center itself around the 1990 Gun Free Zone Act. It centers itself around the second vocabulary word or concept, which is the interstate commerce clause. And this clause gives Congress the power to, and I quote, regulate commerce with foreign nations, that's first, and among several states or each other, and with the Indian population. Because remember, Indian population, at least their land was considered federal grounds, and not just federal grounds, but their specific grounds, like as in Indian grounds. So therefore, it was our trading with them also. Also, keep in mind, in the same perspective, that the Constitution does not explicitly define the word in regards of regulate or regards the concept of commerce. Some argue that it refers simply to trade or exchange. Now I'm talking specifically about commerce. So the common thought or theme here is that people, politicians, and everyone across the country believed that commerce itself was that it refers specifically and directly to simply to trade or exchange of goods and services, while others claim that the framers of the Constitution, our John Jays and our Alexander Hamiltons and Benjamin Franklins, right, intended to describe more broadly commercial and social intercourse between citizens in different states. In other words, any type of exchange, maybe of ideas, perspectives, services, goods, things of that nature. Everything that's encompassing of some type of exchange will be considered a commerce. Because of this, the interpretation of commerce affects the appropriate dividing line between the federal and state power. So this is much more of a power struggle. At the same time of understanding specifically what commerce happens to be. Is it just a physical exchange of ideas, goods, and services, or is it the concept of ideas itself, right, being exchanged, or is it just the concept of something from one state to the other, or maybe the power lies within the federal government or within the state? It's a lot of ambiguity, within this concept, right? A lot of ambiguity. So keep this in mind when we continue on the process of this case, because this case goes a different direction than what you may think. Now, the central question that's here is that does the 1990 gun-free school zone, the act itself prohibiting persons from carrying a gun at a public, private, or parochial school, unconstitutional because it extends the authority of Congress to legislate under the Commerce Clause? And basically, the central question is answered as yes, right? It is prohibiting persons from carrying a gun at a public, private, or parochial school, right? It makes it unconstitutional, all right, because it extends the authority of the Congress. And not just that, it also allows the concept of Commerce Clause, the exchange, right? So again, having a gun on the area, within the area of school zone itself, would be considered a Commerce Clause act, not just a crime of having possession of the gun or the weaponry itself, right? It's just the perspective of the possibility of the exchange of that good. The possession of a firearm in a school zone is not an economic activity that might, through numerous repetition elsewhere, have an effect or commerce clause. This is just my personal perspective here, right? Just because I may carry a gun, let's say we live in an open carry area of Louisiana, and I have a gun in my possession, particularly in my vehicle. It has nothing to do with the economic perspective, right? Whatsoever. It has everything to do with outside of economics. It cannot have an effect specifically on the concept of interstate commerce because of the exchange of that good for a different good or a good for a service or so on and so forth. I know it's a little tricky, a lot of ambiguity, but we'll get into the reason why this case is super important in just a second. Just bear with me. All right, background information. So the respondent is Alfonso Lopez Jr. He's a senior at Edison High School. Now he carried a concealed 38 caliber handgun, and 5 bullets rumors grabbed the school authorities' attention and confronted him. All right. So in other words, so he's carrying this gun and carrying these bullets. School authorities saw that he was doing this, or it brought to his attention that he had this particular weapon on hand, and they confronted him about the weapon and the bullet itself, or bullets. So Alfonso admitted to obtaining a gun. So he was arrested and charged for the Gun-Free Zone Act of 1990, which in turn is an actual federal offense. Remember, states didn't issue this particular law. The federal government did, solely for the purpose of protecting our schools. So he's charged with a federal offense. And this federal offense is basically any person that possesses a firearm at a place that an individual knows or has a reason to believe it is a school zone. He knew he's at school, he has a gun, we're going to arrest him because he violated this act. Not because he's underage with a gun. He just has a gun that in a school zone overall. So he's arrested for that, not the age restriction of it itself. As we continue on with the background perspective of it, the one question that we have here is, why was this case the Supreme Court wanted to hear? Or why was it this case in particular? The Supreme Court said, you know what, it might be a good idea to hear this case. Right? So the main argument was that the act is valid, the Gun Free Zone Act is valid because possession of a firearm in a local school zone or within 1,000 feet does indeed substantially affect interstate commerce. While many of the Supreme Court justices truly believed that not only is it detrimental for the well-being of the students themselves, it also violates the interstate commerce clause itself. Not just that, the possession of a firearm in a school zone may result in violent crimes. And that violent crime can be expected to affect the functioning of the national economy in two ways. So what they're saying is this, everybody, that one, it is the effect of interstate commerce because it has some type of effect on the economy. At least the argument is simply stated this way. But there's two specific arguments as to why this has a long-term and even a short-term ramifications to the national economy. The two functioning perspectives in regards to the national economy is one, the costs of violent crimes are substantial. And through the mechanism of insurance, those costs are spread throughout the population. In other words, when individuals are harmed, insurance rates go up. The insurance rates go up not just for the individual or individuals, but it also goes up for the school. So it has economic implications. And you might be asking, how does it go up for the school? Because the school has to claim the fact that there was a shooting on school grounds. And therefore, the insurance company must assess the situation and therefore issue funds, possibly, for any damages to the school if someone is shot, but not just someone, if something in the school has been shot, something is damaged, so on and so forth. And the second functional perspective is that violent crime reduces the willingness of individuals to travel to areas within the country that are perceived to be unsafe. So what they're saying here is that if they perceive a general store, right, to be highly unsafe because of the environment in which it is in, when the environment may still be within a school zone, then and only then, that particular, whether in New York as a bodega or whether you in anywhere else as a corner store, they lose business. They lose money because they're unable to obtain the customers based upon where they are in the community. Also, the presence of guns in schools poses a substantial threat to the educational process by threatening the learning environment itself. So there's also the concept that if you have a gun in school, then that particular person is not focused on the concept of education. He or she is focused on some type of retribution or some type of harm upon teachers, upon faculty, upon staff, upon students, more importantly. So basically, look, the government is just looking out for the best interest of the good of the people. which is why they created the 1990 Gun Free School Zone Act. But not just looking out for the interest of the people and the safety and whether they are comfortable with their educational setting, to ensure that their educational setting itself is comfortable, is you're able to learn effectively and efficiently and thoroughly from bell to bell. A gun in a school zone is a big deal. We all know this, right? Because we have seen this firsthand. Many of you were way too young in regards of Columbine in the mid 1990s, but mid to late 1990s. But this also was Newtown. You also have situations that happen at Stoneman Douglas. So it's a huge deal and should be taken seriously because it affects us all emotionally, obviously physically if we're involved in it as well, and sometimes to a certain expectations, so, spiritually as well. So let's get directly into the case. So Lopez moved to dismiss the indictment. So him and his lawyers moved to dismiss the indictment that was placed upon them, saying the act itself was unconstitutional as it is beyond the power of Congress to legislate control over public schools. In, excuse me, in other words, they're not advocating the fact that Lopez is guilty of having a concealed weapon. They acknowledge the fact that he does. What they are fighting is the fact that the law itself, the 1990 Gun Free School Zone Act itself, is unconstitutional because it gives Congress way too much power to legislate over our schools. It provides Congress an enormous amount of power to do what they feel is necessary for a school to be effective and efficient. And by the fact that having this much power actually harms students, the faculty, and all people of that nature. Now, it's a far fetched thought process, right? You admit, technically speaking, he had the gun. Administration knows he had the gun. They confronted him. He admits to having the gun on hand. However, he is trying to rule out this concept because he's trying to make sure that Congress doesn't have as much power, which is his only way to get out of the possibility of going to federal prison. Now, the court that first tried this case in the United States District Court for the Southern District of Texas, basically within San Antonio, really within the court is happening in Austin here, ruled against Lopez, right? So they're stating on the district level, look, Lopez is wrong, stating that it was within the congressional powers to regulate activities affecting commerce. But not just that, it's the business of elementary, middle, and high schools affects commerce itself. So what commerce is there to do is harmed by some student coming in with a weapon that can harm the ability of effective teaching, effective business practices for nearby businesses, as well as the mental, physical, and spiritual harm that it happens upon students, faculty, and staff. Now, after Lopez was tried and convicted of this crime, he appealed to the Fifth Circuit Court of Appeals to try to overturn what happened in the U.S. District Court. Lopez's case was heard, and the Fifth Circuit Court ruled that Congress's actions were not covered by the Commerce Clause, basically reversing his conviction. So, while his conviction wasn't reversed on the district level, his conviction was reversed on a Circuit Court of Appeals level. Or in other words, the appellate level, it was overturned. Now Lopez becomes a free citizen. Immediately thereafter, the U.S. federal government filed a petition of Satori, right, to certify this concept, right, to take another look so that the Supreme Court could hear the case. In other words, the U.S. federal government lost the case. The U.S. government believed that he, Mr. Lopez, is a danger to society and danger to other students at the school. They immediately filed an appeal and appealed the decision to the Supreme Court, which in turn brings back to the previous couple slides the fact that they were anxious to hear this case and hear the arguments to determine one, was the 1990 Gun Free School Zone Act constitutional? And also the fact that is it right for an individual who was found guilty initially, then was overturned because the constitutional law itself was too broad for Congress itself. But they was also looking into it because they also was looking at the power in which Congress has, and does Congress have too much power? Is Congress's power too broad? Now, once it goes to the Supreme Court, the U.S. versus Lopez case was heard in 1994 and decided in April 1995. So it took a couple of months. Then a few months thereafter, it came up with a decision. And the decision came from Chief Justice William Rehnquist. Now, the United States government's main argument against Lopez consisted of several parts. So the United States federal government is giving these arguments to him, to the Supreme Court, and they give them these arguments on several main concepts, right? One of them is that the possession of a firearm in an educational environment would most likely lead to violent crime. So if someone has a gun and they bring that gun to the school, more times than not, they're trying to use the gun to harm people, not to have as some statute, right? Not to have as some toy to show people at show and tell. The second concept is that the violent crime would cause insurance costs to raise significantly all over the country. And what I mean by all over the country, the rates for individual insurance rates if someone either dies or gets injured significantly, the rates for so many others, it's a ripple effect. It goes up. Maybe the rates for the insurance of the school when school property is damaged goes up also. If someone sues the school district because a young child has a gun and starts shooting, then their insurance rate, that in particular insurance rates, goes up because of that school system being sued. But also, the presence of firearms in schools will cause safety concerns. Kind of goes right back to the concept of the first part. And inhibiting education which could in turn weaken the economy. So when you have less educated individuals, you don't have individuals doing a lot of the work in regards of being a lawyer, a doctor, a nurse, Wall Street agent, doesn't matter, right? You have less people in those particular areas and those particular viewpoints and perspectives, which in turn could weaken the economy due to the strong ties between education and financial stability. So with more education becomes much more financial stability that an individual has. And if if a young kid brings firearms to school, the safety for young kids, in those schools significantly drops or lowers, while at the same time the perspective of these same students being able to effectively be productive citizens in society decreases significantly because of the possibility of death and the possibility of dying sooner rather than later. Now, the decision of the case is pretty simple. In a controversial 5-4 decision, the Supreme Court upheld the decisions of the Court of Appeals. So now Mr. Lopez is officially free without any ramifications upon him. he can now be try to be a productive member of society. So he doesn't go back to prison. He doesn't serve time, all this additional time. He argues his case well to the point of where he wins by a very slim vote, but he wins nevertheless. Now, this meant that Congress's power under Commerce Clause were limited. This case limits the power of Congress exponentially, and that these powers did not extend to the regulation of the carrying of handguns. So while it's limited, while the power of Congress is limited significantly, these powers did not extend to the regulation of carrying handguns. So in other words, the Supreme Court did not recognize any massive effect on the economy that the carrying of these handguns may have. They don't see the correlation between, or belief in the correlation between a handgun on a school campus to the possibility of individuals unable to be effective and productive citizens of the United States because of higher educational standards. Also, keep in mind that Judge Rehnquist said that Lopez didn't have to serve time because the Gun Free School Zone Act itself was unconstitutional. Let me put it to you this way, everybody. The Supreme Court acknowledges, without a shadow of a doubt, that Mr. Lopez brought a gun to school, not just to school, but on school campus grounds. Because he did this, major punishment is needed. They agree with that. He is guilty for having a gun on school campus and school grounds. But just because he has this gun on school grounds does not mean overall that it, pardon the pun, trumps the concept of the act itself being unconstitutional. So let's look at it this way. If a child gets a cookie from the cookie jar, walk around with that cookie. The problem with that cookie is that um, it has too many calories, which can harm someone. So therefore, you shouldn't bring this particular cookie and walk around with it and then later on eat it. Because of that, we're going to punish you for doing so. This act is saying you're not going to punish said person for getting a cookie because we know this cookie is wrong to eat. However, not because you said the cookie, or at least the argument is that the cookie has too much calories and therefore can significantly harm someone. We are judging you based upon the perspective of what's beneficial for the people, and either to limit the power of Congress or enhance the power of Congress. To limit the power of the people or to enhance the power to the people. Also note about the majority opinion. Now I told you that Judge Rehnquist gave it the opinion overall. Let me go over what was Chief Justice John Rehnquist has to say regarding why he and his fellow justices voted the way they did. Now, Justice Rehnquist is bringing in and is bringing in the agreement of Justice Sandra Day O'Connor, Justice Scalia, Justice Kennedy, and Justice Thomas. So he brings in these other four individuals and state this, that one, channels of the interstate commerce. So this concept itself channels the interstate commerce clause itself, which makes it unconstitutional. At least that particular clause, which is the Gun Free School Zone Act. The instrumentalities of interstate commerce are the persons or things in the interstate commerce itself. So he's stating, along with the other four justices, that there were three broad categories of activity that Congress could regulate. Right? He said this is how you can get around the perspective of interstate commerce as it pertains to this particular act. And the third concept is that activities that substantially affect or substantially relate to interstate commerce. So the School Zone Act, the Gun Free School Zone Act, must be able to have channels of interstate commerce, not being so broad of the interstate commerce. They must have instrumentalities of interstate commerce. In other words, they should be able to have some concepts of interstate commerce written within the act itself. But not just that, they must have activities that substantially affect and relate to interstate commerce. So they must have some type of activity within there to link directly to the concept of interstate commerce. And the Gun Free School Zone Act does not do this. Therefore, it is unconstitutional. But also keep in mind about the dissenting opinion, which comes from Justice Stevens, Justice Souter, Justice Ginsburg, and Justice Breyer. Now, they come together and say three of which wrote dissenting opinions, right? And the three that wrote it were Ginsburg, Stevens, not mistaken, and Breyer. Now, the most important of which was Breyer's. And Breyer's opinion specifically stated that the principle of the dissenting opinions claims that one, the Commerce Clause included the power to regulate local activities, as long as they slightly affected interstate commerce. Even if it slightly affects interstate commerce, he still committed a crime by bringing the gun to school. In considering a question, the court should not look just at the case at hand, but similar acts. In other words, they must look at other actions that's similar in scope to come up with an answer that is sufficient, but not just sufficient, but also be able to end all the lines in regards of the ambiguity within the interstate commerce. But also the third concept, that the court should not have determined if it was an activity that significantly affected interstate commerce. Breyer is saying this isn't the court shouldn't be looking at the activity in which it possibly could affect interstate commerce, but it should have considered whether there rational basis for Congress concluding that. So was there a rational basis for Congress to create the Interstate Commerce Clause, but not just that, also to create the Gun Free School Zone Act for its actual intended purposes? Breyer is saying the intention is much more important than linking to a commerce clause. The intention was to save lives. The intention was to prolong the life of young men, women, and children. Now, the historical significance here. The historical significance here is this. U.S. versus Lopez raised several questions that are still debated today, right? And lead to further legislation on firearm possession near schools. It continues the debate itself in regards of having pieces of legislation to help and save the lives of many people. But not just save the lives of many people, but just by the fact of having firearms on school grounds. The Federal School Zone Act, or Gun Free School Zone Act, was revised in 95 to work around the problems it had that allowed it to be in question in U.S. versus Lopez. So it not only deals with the safety issues within schools, it also deals with it also confronts the perspective, excuse me, it also confronts the perspective of the Interstate Commerce Clause. Also, while Congress may not have the power to regulate carrying of firearms under the Commerce Clause, gun control legislation has become a hot button issue, right? So Congress specifically does no longer has the power to regulate carrying of firearms under the Commerce Clause. However, Congress does have the power to create legislation in regards of students having guns on campus in the form of a weapon, not in the concept of the economy. Many of you might still be confused by this. Let me put it to you this way. Congress has no power to create legislation when it comes to the Federal Gun Free School Zone Act, when it pertains to the economic factor of school zone itself. In other words, there's no way possible to know the ramifications that having a gun on campus deals directly with the economy. Um, um, Local bodegas and local corner stores that centers around the school system, or the concept of how an individual or how students can grow in their role as students and become better citizens, but more importantly, have a way to be successful outside of school and determine like their economic status, monetary status. Congress doesn't have that power to regulate that, but Congress does have the power to regulate if schools, if people can have guns within a school zone, even if it is a open carry state like Texas or any other state of that nature. All right, this leads to the ending of the slideshow itself. I hope I brought some clarity in regards of this case. It's an interesting yet complex case. The case itself still has major debates within itself overall as to the power of Congress, but also the legislation centered around guns. I know we will have more discussions about this when we get back to school, but this is the basic perspective of what this case is all about. Again, it talks about the Commerce Clause and how it deals directly with education, but more important is education, economy, excuse me. Much more about the economy. It deals directly with a young kid having a gun on school grounds. So it's not just a situation about having guns in the hands of a minor. It's about the economic factor itself. Understanding why the Supreme Court case wanted to hear this, to delineate the power, to delineate itself from Congress, to understand the power Congress has, to either limit that power or expand it or keep it the same, while also being able to fundamentally understand and try to change the laws in which gun ownership and gun rights actually have as well. So there's so many different functionalities and concepts in regards to this case itself. So with that in mind, I will provide this for you and other manipulatives that you would need in regards of this case. If you have any questions, comments, or concerns, please let me know. Email me. Be more than happy to help you out. As always, please be safe, be healthy, be responsible. Make sure that you're good. Overall, your family are good, and we'll get through these trying times again. Also, as I said before in my message to you all, please have or create a journal because this is history that we're living through. One day you might want to write a book about what you're going through in this mass hysteria, which is COVID-19. So again, I will talk to you soon. Email me if you have any questions and other manipulatives that will match. U.S. versus Lopez will be available with this. Hope everybody have a great day. Take care. See you soon.